Hey there, everybody. We're going to give a new time slot a try here in Virtual Legality in the Hoeg Law YouTube channel. Welcome. If you haven't been here before, this is Question Time, January 2022, where folks from the community and folks that support the channel on Patreon can ask me questions. Now, we accept almost every kind of question here, and we try to handle them with aplomb and political eyes as much as we can, trying to avoid problems. But one type of question that we can't answer, if you don't already know, is questions about your specific legal situation. As you see, every video in Virtual Legality, we have a disclaimer at the end that says, I'm not your lawyer, this isn't official legal advice, this is for educational, informational purposes only, and that continues here in Question Time. Outside of that, I think I've had questions about which kind of pickle I prefer, what movies I like, what books I read. So please feel free to start putting those forth as the community once we get started. Before we get started with community questions, though, this is a Patreon-supported video endeavor. Question Time couldn't be possible without support from viewers and listeners like you through Patreon. One of the tiers allows patrons to ask questions specifically for this purpose. It's why this show exists. And so we always do try to cover those specific Patreon questions first and foremost in this space with some shiny slides. Like to make those slides that you've seen probably in episodes of Virtual Legality before, because we do like to cover people's quotes and we try to avoid content ID and other problems that are not maybe that fair use related as far as we go. So we try to do them in quotes, and we do the questions that patrons ask, just like this one. So with that being said, we've got 4 patron questions to discuss today. Let's dive in. When looking at developing contracts and giving legal advice, how do you balance focused perspectives of state versus federal law? Now, for those of you that don't know, or honestly didn't care because I'm out here talking about video games, my background is a commercial transactions lawyer. I do business law. I don't go into courts. I don't do litigation of any kind. I'm not the lawyer you see on Law and Order objecting to things, although we like to make the jokes here because that's what people think about lawyers in general. I do contracts. I help businesses get formed and funded and have their contracts drafted with their employees, their vendors, or otherwise. And I do this in my day job. So this is a good question for me. How do you look at contracts? What do you think about with respect to governing law? The first answer to that is you're always trying to evaluate what makes the most sense for your client. Your client is going to have specific needs, whether that's an end user license agreement for a piece of software that they've made, or an evaluation of a contract that's coming into them from some big customer that they otherwise want to provide services for. And part of that is evaluating each and every term, how it operates, basically on the assumption that it's valid. Right? A lot of people come into this channel and say, well, that might not be valid. That might be void for public policy. A court might step in, particularly in California, where they are more likely to do that. But my job as a lawyer is effectively to look at a contract that I'm either drafting or reviewing and say, okay, let's assume all this will be enforced against my client. So before we even start talking about state and federal rules and everything else, I'm going through every term of that contract and saying, hey, if this is enforced against us, this is going to be a problem for X, Y, or Z reason. We should do a carve out. We should change this language. We should negotiate in this specific way. Outside of that, however, you can get into discussions of, all right, they've said it's going to be governed by New York law. It's going to be governed by Michigan law. It's going to be governed by California law. What do we need to be concerned about there? And the way the practice of law in the United States work is I am licensed to practice law in Michigan, but all of my business clients have interactions outside of the state of Michigan and any number of contracts that are governed by any number of different laws. For the most part, that's okay. Almost all the states kind of cover things the same way. But in a couple of instances, like California, there's some specific areas in Massachusetts and New York that you have to worry about. You're going to be looking at that and making sure that the governing law matches some basis for what the contract's actually doing. Is there somebody in that state? Is one of the companies actually incorporated in that state? Something that connects them. And then you're going to make sure that that's okay with your client. And for the most part, it's going to be. In terms of federal law, it's not coming up quite as much. Contracts are mostly going to be evaluated on a state level basis under the governing law that's put forth in that contract. You'll have a specific provision. If you go and you look at my analysis of a game development agreement, you'll see a specific provision that talks about what state governing law actually covers this particular contract. And outside of getting popped out of that, the United States on the whole, and you've heard me say it a lot in virtual legality, wants to enforce the terms that people put forth in a contract. So if they say, hey, it's Michigan law, then it's going to be Michigan law, unless, it's two companies from Germany saying Michigan law. Then it doesn't have to be that way. You have to have some kind of connection with it. So when you're balancing things, you're trying to evaluate, first and foremost, what your client needs, what the other side wants, assuming it's all going to be valid. And then you're having conversations. If somebody tries to put a non-compete on you, but then they say it's governed by California law, one of the conversations you wind up having is they don't love to enforce these. So client, you need to evaluate whether you're going to push too terribly hard on this, because if push came to shove, we might be able to push pretty hard on it later, and having those kinds of conversations as well. But outside of that, the feds aren't really getting involved that much unless it is a federally focused contract, something that actually goes through the federal regulations. You have to evaluate those, and there's a whole host of other things that go along with that. But that's substance-based, and thank you very much for the question. Question number 2. Will you cover Epic's recent appeal to the Ninth Circuit and that it has also been supported by 37 states and the Department of Justice? And I got flagged on that particular point, the last part, over the last 48 hours by I don't even know how many people. So what happens when you appeal? So Epic lost its case. Epic has appealed to the Ninth Circuit, the Court of Appeals directly above the state of California court in which it filed its original complaint. It's appealing, saying, hey, the district court got it wrong. Let's change all of this. And as a part of that appeals process, you can collect briefs that are from, quote unquote, friends of the court, and they can say, hey, this is how it would affect us. We're not a party to this particular complaint. We think that this argument should hold water. I have not read through the brief that the attorneys general of 37 states and the Department of Justice have filed on this. I've read summaries of it. I don't really feel 100% comfortable talking about the substance, other than to note that they aren't parties, and their interests in getting something one way or the other doesn't actually change the legal analysis, or at least it shouldn't, right? There's always optics, there's always politics whenever we discuss any of these issues. But overall, those particular attorneys general want to argue that Apple should have to be cracked open, just like Epic does. And one of the things I think you've heard me say in virtual legality a lot is the one bipartisan thing that the politicians of the United States can agree on right now is that big technology has too much power. Democrats, Republicans, the political class doesn't like what big tech is doing, maybe justifiably so, maybe not. But when you get political offices like attorneys general, they say states, but it's really the attorneys general in those states, advocating for this particular position, a lot of that is, hey, let's take big tech down a notch. Maybe that's appropriate. I have to look at their briefs. Epic unfortunately filed an appeal that I think is 98 pages long or something along those lines. I haven't gotten a chance to read it yet because the law firm's been doing great, thanks, and the video channel's been doing great. Obviously, with Activision and Microsoft, we've had a lot to cover. So that's on my list, but I haven't yet gotten to it. I'm not as convinced that a lot of video coverage in this particular period of the appeals process makes a ton of sense. We should get a response brief from Apple, I think in March. It might have been May. I think it's a month that starts with M. And at that point, we might be able to evaluate things a little better. So I'm kind of holding off on it until I don't have breaking news or something that I really want to cover that day. But I think the answer to this question is yes. Epic versus Apple is not a finished playlist on this channel. I just don't want to oversell the value of an appeals brief or even a Friends of the Court brief, because they're important, they're useful, a court can make their decision based off of them. It's not really a volume play. You see 37 states, you say, oh, it's almost the whole country. It's not really like that. And so I want to evaluate them a little more. As soon as I get a chance to read them, I'll see if there's a video in there, but I do intend to catch up on that information. Thank you for the question. Question 3. The not great port of Final Fantasy VII Remake is now available on PC, and interestingly, the reviews provided by Epic Games Store are links to the PS4 version of the game. Is this riding the line between technically legal and morally irresponsible? Well, I think probably. Epic Games sometimes just runs that line, right? There's a reason they've been in the channel so often. But it depends. I know you hate that from a lawyer, and that's the answer lawyers like to give. But if it's obvious on its face when you go to a link that it's a different version of the game, it's probably not that egregious a problem for Epic to be linking directly to it. They probably should be labeling it. They probably should be marking it better. But if the first block of information that's in one of those reviews says version PlayStation 4 or even PlayStation 5, that should be enough notice for a customer to make that evaluation. Now, they won't be expecting to be linked to a different version of the game, so that's its own problem. But it's not, to my mind, it's not the kind of thing that you're really dragging someone to task for if they make this kind of thing. That said, I do think it's the kind of practice that should be looked down on outside of the legal perspective, right? And we always talk about the differences between business and law and public relations and crowds and whatnot. I do think it's unwarranted. I wouldn't want to be looking at a version of a game and be linked to another version outside of that small period of time when maybe those are the only reviews available. And I think you can have a certain amount of understanding if that's the case, but that should be changed over as soon as you do get those PC reviews. I don't play the Final Fantasy VII Remake on PC, so I don't know whether it's a not great port. I think I saw articles and news about that. But I played it on PlayStation 5, loved it. Obviously, one of my favorite games of 2020. The DLC was one of my favorite games of 2021. If the folks that want to play it on PC are not getting a good version, that's really just disappointing to me. And if Epic is pointing people to reviews that are better in order to kind of confuse folks, that's not right. It doesn't make it illegal necessarily. It might not be false, but it isn't the best thing to have going on. So I hear why this question is being raised. I don't think it necessarily rises to a legal problem. I think it does kind of ride that line, but I have no problem with people saying that's the kind of thing that shouldn't happen when you're marketing games. And I'm also not positive whether that's Epic or whether that's Square Enix. I don't know who's responsible exactly for those entries and controlling those storefronts. So thank you for the question. I don't think it's great, probably not illegal. And we'll move on to the last question from patrons. Question 4, what aspects of negotiating are taught in law school? Almost none. Law school, at least as I went to it, and there's kind of different philosophies of law schools. I went to the University of Michigan, top 10 law school in the United States. And the basic philosophy of elite law schools in America is that they shouldn't be teaching specific technical skills or substance on specific points. It's effectively 3 years of trying to teach you how to think like a lawyer and not bog you down with actual facts that you might need to practice law. Reasonable minds can differ as to whether that's a good way to teach the legal system and the practice of law in general. But what it does mean is you get a lot of precedent. You talk about a lot of the way the Supreme Court decides things. You look at a lot of those kinds of cases. Baseline rules. Here's how consideration works. Here's how a contract works. Here's what proximate cause is. Here's what a tort is. All throughout for 3 years. And then you get out and then you realize that basically actually being a lawyer out in the world, especially a business transactions lawyer where you don't have anything that approaches that in law school, with one exception, which I'll talk about in just a second, that you don't know anything about how to practice law. So you get a first-year associate out there at a law firm. And I don't know if you remember the show Scrubs, but there's a scene at the end of the first episode of the pilot of Scrubs where Zach Braff, the main character, and it might not be at the end, it might be in the middle, is standing in the middle of his hospital hallway and people are just running by him and he realizes he doesn't know anything about how to be a doctor. And that came out roughly the same time as I was a first-year associate. And I remember thinking that it so perfectly captured the notion of being a professional and going from school to the work environment and just how little you're actually prepared for that transition. And I think I'm a pretty good lawyer now, but it's 15 years later, 16 years later, God, time flies. And I still remember how overwhelmed I felt to start out with. So if you are a law student, if you are somebody that's looking at this, or you're a first year or a second year, and you're looking at it and saying, my God, I don't know what I'm doing and all this stuff, know that you're not alone on that kind of thing. I mentored a number of folks after I grew up a little bit in the law, and one of the things I would tell them is you're going to make a mistake. You're going to make a mistake basically every day. Try to make it one that doesn't blow up your contract, kill your client, make your partners go crazy. You're going to make a mistake and learn from it and don't do it the next time and go on from there. And understand that every drive home you make for a year or more, you're going to feel bad about something that you did. And it sounds bad, but it's really a tremendous growing process. And I'm thankful that I had to go through it, even though I wasn't so thankful at the time. So they teach you nothing, which leads us to the second aspect of the question. What aspects did you learn after law school? Almost everything. And the one exception I promised to tell you about was there are practicums, there are things even at the elite law schools in the United States that you can do to focus on something. So I did take a business practicum, interacting with the board of directors, talking about contract terms. And one of my mentors, the person that hired me out of law school, actually took on the role of teaching a contract negotiation class at the University of Michigan, my alma mater, which I thought was fantastic. And I think all law schools should be doing that kind of thing more often, because not everybody goes into litigation. Not everybody goes into politics. And the elite schools are often kind of pushing you into appeals courts and politics and things like that. A lot of people go into different areas, including business law. So those are the 4 questions from the Patreons. I do want to thank everybody who supports us through that. We cannot do this kind of stuff. People ask me, I'm a lawyer, I can make money doing law practice, and that's absolutely right. But when I'm doing this stuff, I'm not doing law practice. I'm not billing out at legal rates. I'm not doing that kind of thing. And unfortunately, that means that the return on investment is completely skewed. Any reasonable person trying to maximize their dollar amounts, the value of their work product or whatever, would not do what we do here, which is talk to you all for free almost every day on topics that are hopefully of interest to you. So if you do like it, if you find value here, check out the Patreon because it is so very useful to keeping the lights on, keeping this going. And now that we're at, I think, more than a third of my time doing this kind of stuff, justifying its existence when it definitely doesn't provide as much value in terms of revenue as actually running Hoeg Law and doing that kind of work. So I appreciate everybody that understands that. Thank you so much. I'll answer that in comments when people ask. But that's really what it's all about. When I'm doing this, I'm not doing law. So it's essentially giving up that revenue and that possibility to have these conversations with you, which I think are important, and I am more than happy to have them. But the support helps so much. So please do check it out. Now, let's talk about some community questions. I see a super chat from Uncivil Law. I was just on with Uncivil Law. Was it yesterday? The days run long here in the pandemic. While we were talking about the bail issue in the Rittenhouse case. So it's very nice to see you. Your channel seems to have the momentum of a runaway freight train. Why are you so popular? Asks Uncivil Law. And I feel this feels like a trap. There's gonna be a second super chat or other question that reveals the trap to us on this. But I think the answer to that is hopefully when I'm doing things right, we're creating educational and entertaining information at the same time. And certainly the momentum from the last 10 days or so is that I went on 14 shows and we were talking about Microsoft and Activision every day. And that's fascinating. In fact, if you want to catch me, I'm on another show today at 4 p.m. Eastern. And that'll be linked. I think probably I'll retweet it in my Twitter if you follow me over there. But Microsoft and Activision is such a big story. It's such an interesting story that I think a number of folks are interested in it. So you look at the uploads we've been doing, Microsoft times Activision is already, I don't even know, 8, 9, 10. And they're all getting, some good views. And it continues to have new stories about it. And of course, from support like the network of law tubers and the conversations that we've had from folks like Uncivil Law, every little bit of that helps. When I say at the end of every one of my videos, every little bit helps. You upvote something, that helps. You put it on a Reddit post, that helps. You talk about it on your channel, that helps. And I'm so very, very appreciative of all the people who seem to like what I'm doing here. And I want to keep doing it. So I think it's fantastic. Thank you so much for the super chat, Uncivil Law. And if you do want to have your question asked and answered here, super chats are great. That support is more than welcome. I'm super thankful for it. Don't feel like you're obligated to do that. Also, just flagging it with an @Hoeg Law, HOEGLAW, highlights it for me as a question I should pay attention to. And if I miss you, I apologize. I know people say, well, this isn't the fastest moving chat. Other folks are better at it than I am. That is undoubtedly the case. I think virtually everybody is better at looking at the chat and answering those questions than I am. Doing my best. I don't live stream that often, so please bear with me if I don't see your question, and don't hesitate to ask it again if you see me answering other people's questions and, frankly, you resent it. I understand that as well. Ojericho with a $10 super chat. Number one fan. That's just a picture. That's a dancing exercising pair that says number. I didn't even know those things existed. Well, that's awesome. Thank you so much. It's very cute. It actually reminds me, I don't know how many of you are playing video games, like to play video games, hopefully a number of you if you're here in Virtual Legality. But the new Pokemon Arceus came out, and my daughter and I and the family are having a Pokemon weekend. Mom came out, made strawberries and blueberries and bananas that in the shape of a Pokeball. If you can kind of imagine that with the blueberries as the line in the middle. She's playing Pokemon. I got to be honest with you. One, the graphics a little bit better than they were in the trailers. Not a ton, nothing to write home about, but a little bit better, a little bit more solid. And she's having a blast with it. Seems like they made some really good changes to their overall baseline model, and she couldn't love it more. So that's fantastic. Thank you for the #1 fan. I've never gotten one of those. That is super cool. If you're not in the chat, you could check it out. It's a cartoon pair dancing, and I'm very appreciative of that. Let's see here. What else we got? Hello, Hoeg Law. Why did monopoly and antitrust laws not prevent Disney from acquiring 20th Century Fox? Well, they did a little bit. If you actually followed that deal, Fox had to divest itself of certain news resources due to concerns about consolidation in the news side of the market. But overall, legacy media was looked at and said, well, there's still enough studios, there's still enough content providers. And also it was an environment where Netflix and Amazon and others were busy starting to create more content. More studios were being developed at a very large scale at the same time. Now, I do think people like to point to Disney and Fox and say, well, that's why Microsoft Activision should be fine. And I think it's a good argument. I think Microsoft will make that argument. Hey, it's $70 billion. There's still all these other competitors in gaming, et cetera, et cetera. I'm not concerned about the goodness of Microsoft's argument. I'm concerned about the politics of the day. When you look and you see 37 states attorneys general arguing on the Epic side against Apple, at least some of that is motivated not just by support of Epic, but because they don't like Apple. And Microsoft isn't quite in that hated social media big tech giant space because they're not operating in the same markets. But there are government officials that look at Microsoft and put them in the same bucket. Say, it's a big $2 trillion company. They got too much tech power. Should we evaluate this more closely? And I think it's important to understand that that's a distinct question from, is it a problem that Aliens is now owned by Disney? Is it a problem that The Simpsons is owned by Disney? Whatever. In terms of Fox and Disney, legacy media and just content like that isn't quite the same argument as, okay, the streaming services, okay, Game Pass, what does that mean? The cloud infrastructure, what does that mean? And tech. I think it's important for us to understand that we might know that it's not as big of a deal in terms of concentration of markets and there's all these competitors and all these kinds of things, but that when we talk about antitrust regulation and politicians, they are not as educated as you or I or anybody that watches Virtual Legality is in respect to the digital space, in respect to video games, and that's not really their fault. You can't be an expert on everything, but when we see politicians and law interact specifically with the digital space and modern technologies, weird things can happen. And that's one of the reasons I flagged it for you. That's one of the reasons I did the video that I did. But thank you very much for the question. I'm not seeing any other highlights for Hoeg Law, so please do use that if you got one. Oh, I got another one earlier on. How do monopoly laws really work? How can these huge companies just continue to consolidate to maintain unlimited growth? For example, Microsoft. I like everybody's interested in the monopoly question today, and I think that's good. The answer is, and I think this is fundamental, and I think a lot of you know that in the comments here in Virtual Legality from the start of the Epic versus Apple lawsuit, having a monopoly, having a high level of concentrated market power is not illegal in the United States of America. The United States of America and its antitrust laws want to encourage high levels of competition. And that means that if you're successful in competing on quality, on price, on services provided, whatever it might be, that you might well dominate the market. You might well just be the best that ever was in creating shoelaces. And if you do that and you get to 99% of the shoelace market by acts of competition, lowering prices, increasing quality, getting better stuff out to consumers, making people happy, then the United States, the Federal Trade Commission, and the Department of Justice have all said, we're okay with that. We want that. Monopolies are not illegal. What is illegal is unreasonable retention of that monopoly or use of that monopoly power to quash competitors outside the normal process of competing on quality and price and services, the actual consumer-facing items. And if you look at that and you say, Rick, I don't understand where that line is, it seems pretty vague, you're on the right track. Because what looks like anti-competition is, at some level, we can understand, really, really strong competition, right? If Microsoft were to just buy out EA, Ubisoft, Activision, and more with $100 billion, they would say, look, this is us putting in our resources to crush the competitors. And at some level, they're right? That's what they're doing. And so part of reading those guidelines, part of taking an antitrust class, part of even analyzing the history of antitrust in America is realizing that it's a pretty gray area between running hard against the competition and destroying them in a fashion that the law finds unreasonable. So when you ask, hey, how can these companies get so big? They can get so big as long as they're competing on the grounds that we want them to be competing on, which is making consumers' lives better, lower prices, better quality, whatever it might be. When they start doing mergers, they get a look, because that's the kind of thing that could potentially raise red flags. That's actually a different act than Sherman and Antitrust. It's Clayton Act. And when they do other things behaviorally, that's when they get a look. If Apple had, for instance, raised its cut from 30% to 50%, or anything really, and then somebody sued them for essentially using their monopoly powers in a super competitive way, then that lawsuit would have a much better chance of success than what Epic did, which was that Apple didn't move anything. Apple's at 30%. It was at 30% when it started. It's at 30% now. It sat there and now complained about a behavioral characteristic of the company that had existed for a long, long time. And that's one of the fundamental problems in their lawsuit. It's one of the reasons why I said if you look at that particular playlist, Microsoft and some others would have had a better chance of winning their lawsuit, because Apple was actually taking active steps to do things like block their Game Pass service and other kind of streaming services, because they're protecting their games empire there. And that looks a little bit better. That looks a little bit more like a antitrust violation to a lawsuit. Epic did what they did, deliberately did it, got kicked off, sued for getting kicked off, and had a very bad optics concept in front of the judge. And I think they'll continue to have a bad optics concept in front of the Ninth Circuit. But who knows? Those things can change. We never know exactly how those things are going to go. But that's really what monopoly law is all about. Doing bad things, not just collecting the power in the first place. All right, we have another question. Do you think Microsoft will be fine acquiring another publisher or two law-wise? Well, from a practical perspective, I don't think Microsoft is very likely to acquire another publisher while the Activision acquisition is pending, right? One of the things we've talked about at length now is that the FTC, the DOJ, other regulators, this is the window where they're going to be evaluating this particular acquisition and figuring out whether they think Microsoft causes a problem to competition. So you don't really want to upturn the apple cart. You don't really want to rock the boat on that. So they might purchase somebody small that they're already working with. You never know. But they're not going to do any of these big publishing, hey, it's in all the news deals, I don't think, while the Activision deal is pending. After it finishes, one thing we note here is that the United States doesn't approve deals. They just allow them. So there's still a risk. Well, we see that with Facebook getting sued over Instagram and WhatsApp right now, even though those deals were permitted back when they were made. So Microsoft still has to kind of watch itself. It's one of the reasons I think Sony PlayStation fans should take the Call of Duty announcement from Phil through Twitter a little bit more positively than some are, because there really would be a political cost to turning back on that unless the reasons were good at the time. But I do think that they could purchase additional publishers after the fact. Certainly somebody small, somebody at the $4 or $5 billion level. That's what small means now, right? But will they? I don't know. One of the things that Microsoft is facing right now is whether or not they can actually manage all these publishers. Right? They've never had to do this before. They're reorganizing on the fly because I don't think Activision was an expected purchase until their stock took a dive for them. And they're figuring out what that looks like, whether or not they can allow to have kind of a light hand on all these publishers, whether they need a heavier hand, what they do with the problem child, what exactly this is going to look like in the long term. And Phil Spencer, who I know a number of you like, has never dealt with anything on this scope and size before. So it'll be very interesting to see how they manage the content pipeline, and certainly other publishers have gotten in trouble on that in the past. I'm certainly watching it, and I think it'll be interesting to watch. We do have a new super chat. Gecko Gamer for €5. Is the Blizzard acquisition on a similar scale as the merger between the two. I'm going to need a little bit more. Oh, the merger between Activision and Blizzard. No. The Blizzard was purchased relatively cheaply, I believe. I would have to look that up as far as the value goes from today. Activision, we now know, because we've seen the history a bunch of times, was bought by Bobby Kotick out of bankruptcy for $400,000 a long time ago. And so that merger happens in the early 2010s, I want to say. And so it gained in value from there. All of the video game industry gained in value from there. So that was a smaller kind of deal and when it happened. And then this is bigger. This is essentially combined. This is Call of Duty and World of Warcraft. And those might not be in their heyday. That might not be the maximum value that they've ever had when you look at these things. But it's also not nothing. And so this is a bigger deal. This is the biggest deal in gaming history. I mean, there's no question. It's not even remotely close. And that's why we've covered it as much as we have. Thank you so much for the super chat. Hoeg Law, how do you make the migration from litigation practice to IP transactional law? I was never a litigator. I knew when I was in law school, I didn't want to do litigation. I have an economics degree. I wanted to be involved in business. I wanted to talk through issues facing folks that want to build something. I get my energy from helping people make something. And so contracts, even though they can get testy, even though there aren't as rainbows and sunshine and butterflies as I thought they might be when I was in law school, and can get angry and dark and depressing depending on the day, is still fundamentally making something new happen, getting a deal done. And I get energized by people that, make the big bets. A lot of my book of business are scientists and doctors that have been working on research and want to mortgage their house to put together a commercialization pathway for a technology that could change everybody's lives. I love backing that kind of stuff. I love helping them figure out how corporations and LLCs work and everything like that. But I was never a litigator because I never really wanted to be at that conflict point, regardless of how people, frame you when you're a teenager or what have you. Oh, you like to argue. Oh, you're on the debate team, whatever, both of which are true for me. But I didn't want to be on the litigation side of things. So I always knew I wanted to be contracts. I always knew I wanted to be business. And that's what I did right from the start. And when you do business, I'm not an IP lawyer. There's an actual boutique kind of legal practice that actually just registers copyrights and patents and trademarks and does that kind of thing, does that kind of litigation. I am a tech and software and business lawyer. And when you deal with tech and software and ownership of concepts, you do a lot of intellectual property licensing. And so I have a lot of experience doing that kind of thing. And if you don't know that stuff, you got to learn pretty quick in order to service your clients properly. And that's the fun of the practice of law. That's the fun of doing what I do, is you're constantly learning. You're constantly finding out new stuff. In fact, Virtual Legality was essentially built off of the concept that I was reading things. I had my thoughts, and I thought I could help explain certain concepts I was seeing over and over again better. And so it was in part what I did in the morning to kind of get my brain ready to do the legal practice all day and making that into a series that I thought could help people. Thank you for the question. That's why I get all my legal advice from Hoeg Law YouTube. No. See, you guys do this joke all the time, but it's not legal advice. It's just some guy sitting here talking to you about the law and the news of the day. It's not legal advice. Although I am happy to say that a lot of the comments that I used to get at the start of the channel, which were literally like, can you help me with this rent issue or I'm in jail, that I had to be like, no, go call a lawyer that does this kind of stuff or that is local to you. Those aren't happening nearly as much. So I think the disclaimers and the notion that I'm not a litigator have gotten out to more and more of the people. I think that's a good thing. But don't make that joke. Come on. You're just trying to get me in trouble with the Michigan bar. At Hoeg Law, what are your thoughts on some companies' ambition of utilizing NFTs as a revenue stream? See, this is a setup. This is a setup right here. So if you go into my last video, you see it on your screen right now, Crypto's Creed, and you look at the comments here, you can see that this is probably the video, at least in the last 6 months or so, that the most people have disagreed with me on. And it's effectively a review of the Ubisoft interview, which you might have seen, which has been characterized essentially as them being aloof and out of touch by saying that gamers just don't understand exactly what the NFTs they're looking to do with the Quartz and Digits platform on, I think, currently just Ghost Recon Breakpoint. And all I basically say, and I have a lot of criticism for how they handle their answers in this video. I am pretty harsh on some of the things that they say and the strategies that they've taken. But one of the things I do say in that video is that I'm not willing to throw out the entire concept of something being blockchain and NFT enabled, working to the benefit of a video game experience, as I think the entire industry of people covering this topic is. So I'm always happy to be out of step. I'm always happy to stand on my own hill alone. Mass Effect 2 is the worst Mass Effect. Come at me. And I'm happy to do it. But yeah, I don't see a way that NFTs and those kinds of blockchain-enabled technologies help games right now. I don't. I'm on your side. I'm at the same place you all are. I am a tech lawyer. I have seen miracles happen with things that I would have never anticipated. And I am fully willing to acknowledge that smart people can come up with solutions that I never would have thought of. So I look at it and say, no, it's not there yet. But I don't hate Ubisoft. I don't hate the answers that they gave. I just look at it and say, you're going to have to prove it to me in a different way. And I think network effects and getting access to different things going through the entire Ubisoft network of games could be part of that answer that they can't show when they're just doing these early experiments because they don't exist yet. But I look at that and just say, okay, there's an aggressiveness in the negativity of that response. I can hear that. I can feel it even from my own commenters that that's, a very significant portion. I have no problem with that. And I never, ever have a problem with people disagreeing with me in this space. But my position on this is that I could imagine someone somewhere figuring out a way that is actually beneficial and everybody loves, and 10 years down the line, you say, of course, this was always the way they should have been utilized in this fashion, and it didn't destroy video games, and aha, we're all having fun. Does that mean it'll happen? No. I just like to reserve the right to allow these folks to experiment and see what comes out the pipe. So that's my position. You can go check out those comments. Highly recommend it. Click on this one. Check out those comments. You can see a lot of people angry at me, a lot of people disagreeing, and I don't mind it. Reasonable minds can differ. I like to still think I have a reasonable mind. And even if I'm in a very small minority of that, that's my position. And hopefully that's why you come and visit Virtual Legality and the Hoeg Law YouTube channels. You're going to get my position, regardless of whether or not you agree or disagree with it. Hopefully I justify where that position came from and how I'm talking about what I am talking about. But thank you very much for the trap question. In all honesty, thank you. Let's see here. At Hoeg Law, have you thought about having a guest on to discuss the differences in competition review between different jurisdictions? Oh, like a European lawyer would be awesome. One of the issues there is timeline. Just in terms of actually organizing a guest appearance. You might notice I don't have very many guest appearances here on this channel at all. I do pop in to other people's channels more often. But one of the reasons for that is that Virtual Legality and this channel basically exists in the interperiods between when I'm operating a law firm and performing services for my clients. And so I have to be able to kind of control that, and that's changing every day. I have nights where I think everything's going to be great the next day, and I'll get 3 emails that are emergencies, and my entire schedule has to change. And that's the nature of professional services. I love it. I like that energy, but it does mean that scheduling guests becomes a problem. I don't like to specifically not service my clients in it because there's a scheduled meeting on YouTube. So I try to be very, very careful with that. That's why you see a little less guest services on this channel than you might otherwise. I do want to try to figure out how to organize that better. And in fact, I'm looking at participating in podcasts a little bit more run by others. But as it stands right now, it's very, very difficult. And when you start talking about crossing an ocean, it's difficult to get a time for any practicing lawyer that's going to work with us. And what you wind up getting is delay, and maybe it never happens. And so I have to work on that better. But right now, what I can control is me doing this when I can, as I can. And that's how you get as much content from this channel as you do, is I can, prep one, do a document review, get on an angry call with opposing counsel, tape it, do the same thing again, and then upload it and work around that schedule without having to worry about other bodies. So that's why you get what you get here at the channel. It looks like we got another super chat from Foxwood. What are your thoughts with Game Workshop's IP rules? I did a video on that. You can check out my thoughts on Games Workshop dealing especially with contracts, with influencers and things along those lines. I think it's a company that is very concerned about protecting its intellectual property and a legal side of things, whether that's inside or outside counsel, that takes the sledgehammer approach in a way that I think is pretty untowards. I don't blame them necessarily. Again, that's me coming at it as a corporate lawyer, but I do think it looks bad. I do think there are better ways to handle it. Check out that video. I think for the most part, I tend to call them Warhammer or something in the title, but do check those out. I think it's a problem. I think they could do better. I think that one contract is ridiculous, but I understand where they're coming from. I just think they're handling it the wrong way. We have another €10 super chat from Gecko Gamer. As far as I understand, the EU has similar laws for antitrust. That's right. With the only major difference being that the EU is a bit more iffy on big acquisitions and mergers. Well, like everything, all of this is a function of administrators, right? So you'll have different versions of the FTC and the DOJ, here in the United States happen as administrations change, as personnel change. Same thing in the EU, but historically, at least over the last couple of decades, the EU has been more willing to use its tool set to block things like acquisitions and mergers or cause divestitures. Some of the Fox issues for Disney were coming out of the EU. That was where the problem was, and that's how Fox had to divest some stuff. And so you do see a little bit more aggression out of the EU for those kinds of things, but it doesn't mean that that couldn't change in the future. It's always people. It's people all the way down. People think of corporations as giant cold entities. People think of government agencies the same way. It's still individuals making their own decisions, using their own judgment, making their own mistakes. And that's an important part of understanding how all of this works together. Let's see here. Next, at Hoeg Law. I recently saw a Yang Ye video referring to your work, but mispronouncing your name as Hoeg. I get that one a lot. Does mispronouncing your name happen often? Oh, I answered the question before we got to the question. Yes, I get a lot of Hague. I get a lot of Hog. I get a lot of Hoeg. None of that bothers me. I'm really very easygoing on this stuff. Some people apologize for calling me Rich or that kind of thing. I go by Richard, Rick. I think the internet primarily likes to call me Hoeg because I do think it's a name that is maybe not unusual, but a little less used in a lot of prominent spaces. I don't mind that at all. Love my name. Love my history. Love my family. So I'm okay with any of that. Hoeg is great. I'm trying to remember who really butchered it. I want to say it was Jim Sterling that had like some horrible pronunciation of my name, and some commenters commented on it. And that was funny to me. But hopefully, we get up to a space where virtual legality is known enough that people know it's just a long O. It's just the garden implement with a G at the end. Hoeg. It's all good. But no, I think that's great. Yang Ye does some good stuff. I think I disagree with him on some things somewhat. I think I might have done a video where I disagree with him on this channel. But I think it's always good for more people to be having more conversations about these kinds of topics. So I think that's a great thing. Let's see here. Hoeg Law. In my country, ideologies in the legal system get to the point of criminals being considered victims of society. What is your take on ideologies versus reason in the legal system? Well, I think, and this is a class that I actually took in law school. There's different notions of what a justice system is, right? Are criminals evil? Are they bad actors that hurt things in society? Or are they instead effectively people that society has failed? And that the justice system, the prison system, whatever that looks like in your jurisdiction, is it to punish or is it to rehabilitate? Is it effectively to make them better citizens of society because society otherwise didn't do their job in the first instance? Or is it to punish these bad actors? And I think every justice system effectively has both kinds of categories of people, right? And that's one of the things you'll get. It's a semester-long class. I recommend it if you're in law school. But that you look at these kinds of things, and there are truly evil people that are bad and that society didn't do any wrong. They're bad eggs. And that you have to make sure that the justice system actually controls for those kinds of things. And there are people that are legitimately in bad circumstances that got into a bad situation, and the law is words on a page and can't really take into account the specifics. And so you can get over legislated. You can get folks that maybe shouldn't be there by all rights. And so that's a constant push and pull of the philosophy of actually passing laws and working with them. So I think it's a fascinating question. I don't think it's as easy as just saying that ideologies change that way. It's a part and it's a spectrum of every decision you make as you're organizing your justice system. I would argue that certain aspects of the law right now are far too harsh. Things like the drug laws that came out of the 80s were clearly very, very harsh and are significant portions of the population of the prison system here in the United States still, even after so many states have decriminalized so many aspects of those drug laws. So I think those are things that are constantly being evaluated. But thank you for the question. Hoeg Law. You say EULAs are enforceable in the U.S. Is there any limitations in regards to such contracts when compared to regular contracts? Discussion regarding the idea of a contract of adhesion. Yes. So in general, as I've said before, in the United States, we want to give effect to contracts. We want to give effect to the meeting of the minds that occurs between two contracting parties. But as you can imagine, in a contract of adhesion where you click accept after you scroll down, or maybe they don't even make you scroll down, there is a question whether or not there's a meeting of the minds. Now, generally speaking, the United States in most cases looks at it and says, well, if you're willing to click accept, you're willing to click basically, I read it or I didn't care enough and I just wanted to accept whatever was in here. And for the most part, courts are going to enforce the terms of an end user license agreement against you. But there are things that can go void for public policy. California, as I've mentioned before, likes to do that more often than other jurisdictions. But if you imagine that there was something in a EULA that you accepted to play Crash Bandicoot Team Racing and it said you give up your firstborn child, that wouldn't be enforced. And understanding the difference between that and something that otherwise looks untowards is where the lawyers and the judges make their money, because it's a gray area. So you can always essentially throw yourself on the equity of the court. Look, in your fairness of judgment, Your Honor, and should this really have been enforced against me? I didn't even know this was there, and it wouldn't be standard for a document of this type. So what's reasonable in a market and an end user license agreement actually starts to control what a reasonable consumer should expect is in there. And one of the reasons we do virtual legality deep dives into those kinds of terms of service is that people know what is in there. And in my opinion, what they should fight against. We talk about largesse all the time because I think streamers, people that make their money doing that kind of thing, should be pushing for licensed rights, that effectively publishers of video games get all the benefits of having licensed out this stuff with none of the penalties. They don't have any of the risks that are associated with actually licensing out your information because they just drop the sword of Damocles if they don't like something that's happening. And so I might do another largesse video pretty soon because Bungie actually came out with a comment that was directly on the topic of largesse that I thought really exposed some of the risks that streamers otherwise have. But that's where I'm at with that. EULA is mostly enforceable. There are some things that can be unenforceable if they go past the line of morality, right? We usually use the phrase shock the conscience of the court to describe such things, but it's a little bit, I know it when I see it. Thank you for the question. And I think I have more super chats. Foxwood, again, with a $10 super chat. Is the Warhammer video up to date with new rules? They talked about Arch Warhammer video, which you can use Warhammer settings, but can't use anything made by Game Workshop, including model designs. I believe it's up to date. You can definitely flag me in a comment to that video. I see all the comments, I think, or otherwise email me or hit me on DMs on Twitter if you think there's something I'm missing. I'm happy to keep covering that one. That's a fascinating one. I have a lot of friends and family that talk about Warhammer and Games Workshop in general. So I think it's a very interesting way to see a copyright holder dealing with its fan base, trying not to offend them, but also not caring so much that they do. So I think that video is up to date. Check that out. And if it's not, flag me. Absolutely. Let me know what's missing, and it might well be covered again on this channel. Vex with a $5 super chat. Do you think we should actually be excited for Blizzard being bought by MS, given how video games are controlled by a few major players now? Well, I don't tell anybody how to feel about these specific transactions, and I certainly understand both sides of the coin here. I certainly understand somebody that looks at it and says, you know, consolidation's getting a little hot and heavy, and if this is a trigger point for consolidation, I don't really want to see a gaming industry that's bought in thirds by Microsoft, Tencent, Google, Amazon, whoever, and that doesn't look anything like the gaming industry I grew up with. I can certainly understand someone saying that that's a risk. We're on a precipice. I don't think we're that close to that precipice, but it is the kind of thing that regulators are worried about and that people can be worried about. From my perspective, I've been watching Microsoft interact with this industry for 20 years, and it's always been interesting how they were kind of standoffish about the resources they committed to the Xbox project and what they wanted to do with it, right? So Microsoft always had a ton of money in reserves, always has had a significant cash position, could buy basically the whole industry, and was always very careful about what Xbox was and what they wanted to do. I'm excited by the fact that a major tech player in the United States is willing to throw $100 billion at making this industry work. They see that as a good source of revenue. They see that as a good investment. And I think in general, that's a good sign. That's a sign of a healthy industry when you have these big players willing to throw around that amount of money. And in the long term, or even the medium term, they have to go try to get that money back. And the best way to do that, even though you might be cynical and you think it's microtransactions or what have you, the best way to do that in broad strokes is to provide value to the consumers, to make those folks want to buy things from them. And so with that monetary commitment, with the actual resources available to those developers and publishers under the Microsoft umbrella, I'm excited for the possibilities, but that doesn't mean it can't go wrong. And certainly looking at Disney and Fox and other things that people have mentioned, I do think that there's a risk of, even if things are working out, even if Microsoft is cranking out games, that they become a little bit vanilla, that they become a little bit alike in a way that I think we're seeing a little bit with Disney, right? Like I would prefer that there were a Fox and a Disney because Fox had a different flavor to its movies and Disney makes them samey in a very important way. And so when it's dominated by Marvel and it's dominated by Disney movies, I think we've lost a little something in terms of the options that we have for different tastes. And I think that could happen with Microsoft. I'm hopeful that it doesn't. Phil's saying the right thing, saying I'm going to give them creative control. But if somebody were worried about even that, I could totally understand that. And so, look, I'm a transactions lawyer. I see a $70 billion transaction in my favorite industry. I get excited because that's exciting. It's like a fantasy football team making a major trade or what have you. But I can totally understand not being excited about it. And I totally understand regulators going in a different direction. What else do we got? So it's 12:50. We got about 10 minutes left in our slated time. Might go a little long today. But if you do have questions, get them in. I know I missed some in the middle, so if I missed those, get them in again. And I'll try to hit them, and I have a couple here to go. But I hope everybody's enjoying themselves. I love doing these question times. Very fun. I guess before I want to do those questions, I did want to say, hey, people have been getting down on me on it. I've been enjoying Rainbow Six Extraction. It's on Game Pass. This is one that I've been really enjoying, actually. I didn't expect anything about it, so maybe I'm ruining that enjoyment just telling you that I'm enjoying it. That's kind of an Inception paradox kind of situation, but I've had a lot of fun with it. It has a lot of different aspects to it I wasn't expecting, and if you're just looking for something to chat with your brother while you're playing it for a little while, it's a very good game to do that with. I've also been enjoying a board game series with my daughters, 12 and 10, called Unmatched, where essentially you've got different characters from literature and history, things that are available in the public domain primarily, that have these little tactical fights against each other. So if you didn't know about that one, highly recommend those. I like to tell folks what I'm playing because I love to play and I love to be involved in this industry and otherwise. So with that said, let's answer more questions. At Hoeg Law, do you prefer the four corners approach of Kickstarter or do you prefer the more liberal small L interpretation by the courts CUCC approach? Everywhere and always, I prefer having all of the terms of a document and people understanding their risks and obligations in the four corners of the contract. When you introduce public policy, when you introduce UCC rules, when you introduce interpretations that are outside of that, I think you really risk running afoul of the whole meeting of the minds concept, layering in other structures. I want, in a perfect world, each side to know exactly what they're getting and what they're giving up in that contract and know without doubt that that's what will be enforced for them and that's what will be enforced against them. So I'm a four corners guy. $5 super chat, €5 super chat from Gecko Gamer. Would you argue that entertainment acquisitions and mergers should be judged on variety of product rather than how much the product costs? Well, the cost, the size, only attracts attention because it suggests market concentration. It doesn't actually matter for how they are evaluated. So when we're talking about what's a problem for lessening competition, it's on variety of product. It's on number of producers. One of the things that could bite Microsoft in the butt is not that they're a monopoly in gaming, but that they might be a monopsony purchaser of space on the only recurring revenue subscription service that actually makes sense for people, and how that hurts developers and how that hurts consumers because it hurts developers. That's the kind of argument that I can see happening. But certainly when you're looking at entertainment, when you're looking at content production, it's going to be evaluated not just on market concentration, but also on how much content is being produced and how much that changed based on the transaction that you just engaged in. At Hoeg Law, how do you feel about the AMD X-Link's acquisition approval from China. I didn't see that it was approved from China. I would expect that deal to go through pretty cleanly. But you never know on these things. But that one made sense to me and didn't strike up many antitrust concerns. It's not the same as NVIDIA ARM. Can I file an EEOC lawsuit for not being considered for position or promotion of SCOTUS based on being excluded for my sex and or race? So you used the my's there. And I want to make clear that this isn't legal advice. But generally what you do is you file a charging document with those various bodies in your jurisdiction or the feds. They look into it, and then they give you permission to sue on your own, if they don't want to do it. There's a lot more that goes into it. Consult your local counsel. At Hoeg Law, I agree. I'm very thankful. I don't know what I said that you agreed to, but I'm happy that you agree. Thank you so much. At Hoeg Law, would you rather take a drink of milk thinking it's apple juice or a drink of apple juice thinking it's milk? I think I would rather go from thinking it's apple juice down to milk than the opposite. I think that's a shock to the system if you think it's milk and it comes out with a fruity, tart taste. At Hoeg Law, having been involved in this industry for a while, what aspects to gaming are you disappointed haven't developed as far as you would have hoped? I don't know that I'm disappointed. I kind of try to temper my expectations, and I understand how markets work and say, hey, we're gonna go along with this. We're gonna surf the wave as the publishers do. I would love to see more storytelling. I would love to see more narrative. I think I say this in basically all instances when I'm reviewing something. That's what I love about this. I came to video games through King's Quest and Star Control 2 and Final Fantasy 4 and 6. And that's where I really have seen the things grow. Witcher 3 is a standout in modern times for that kind of storytelling, what you can do with interactivity. And unfortunately, I don't really think that is necessarily where you make the most money. So that might become more and more few and far between. And if I'm disappointed in anything, it's that. But the indies, the folks that are making smaller level games are still doing that to my satisfaction. I'm still enjoying that a lot. So I think we'll still have a gaming industry that's robust and can give you those kinds of experiences. They might just not have photorealistic graphics. At Hoeg Law, just curious, is there any way to ask you questions outside of these Q&A videos? Like, I don't know Twitter or whatever else one might use. Yes and no. I try to respond on Twitter. I will be honest with you. The channel's gotten popular. The Twitter has gotten popular. I get a lot of DMs. I get a lot of messages. I get a lot of flags. If I don't respond to you, that is not because I am deliberately being cold. It's because I'm doing something else and the list goes past you and you fall off the desk. And so I apologize each and every time for that. But I do try to respond to my DMs when I can. And if you flag me in public on Twitter, that's fine too. I will get to those if I can as well. Otherwise, my email is open. I have a law firm email, rhoeg@hoeglaw.com. People do send me questions about virtual legality or YouTube videos. I don't, it's not my preferred method, but you can do that. And then sometimes I'll answer. Sometimes it looks too much like legal advice. It's all kind of facts and circumstances based. But absolutely, reach out to me. This all exists to talk about these kinds of issues because I think they're interesting and I think people can get a lot out of them. It doesn't exist to put things behind paywalls. I mean, one of the reasons the Patreon exists with a question time and not with exclusive content is because I didn't want this to be what I hope is educational, trapped behind paying me money on those kinds of things. I don't know whether that'll change or not. I've been thinking about like behind the scenes type stuff for the Patreon. But ultimately, when I was evaluating this, it was don't put content, don't put substance behind those walls here in virtual legality. Not that there's anything wrong with that for others, but that's not what I wanted to do with what this channel is. I agree at Four Corners contract interpretation. Yep, I'm all about that. What is your top 4 AB games you would like to see MS bring back? Activision Blizzard games. It's selfish, right? I would love to see old school adventure games. I would love to see King's Quest and Space Quest and those kinds of things come back. I don't know whether that's a good investment for them. I don't know if I were sitting in that room and it wasn't me who wants to play a game talking about what your IP can do, saying, yeah, let's make a Space Quest game. But that's what I would see if I had my way. Otherwise, I would see Microsoft really invest in, character-based platformers and fight a little bit more with the Nintendos of the world, with Crash and Spyro under your belt. That's been proven that people like those. So that's probably what I would recommend if you're going to bring back some intellectual property. Gecko Gamer, another €5 super chat. I'm going to get that right before we finish this off, Gecko Gamer. any studio in Activision Blizzard that could possibly be required to be booted out to make the acquisition through. So that's the normal way that you handle an antitrust problem, is you have a divestiture. You require the company to not buy something that it would otherwise buy. The problem is the most obvious one is King, and Microsoft actually doesn't have a presence in mobile that much. So King is the cleanest portion of the purchase, but it's the one where mobile gaming is part of what regulators are most interested in and concerned about, right? So the answer is I don't think divestiture makes a ton of sense to solve an antitrust problem here if you think they have one. So ultimately, no, I don't think that they'd be divesting. I think that you could ask for concessions. You could ask for certain treatments of contracts. You could ask for Call of Duty to stay in specific places. I don't know that they'll get that deep in the weeds. Again, this is how we come out with, I still think the deal's going to go through mostly as it was shown, but I put it at like 80% because a regulator could decide that they want to cause trouble. Let's see here. Careful with Verners, folks. Uncivil Law causing trouble in my chat. Hoeg Law ignores you because he does not love you. That's what he ignored me for months when I wanted to get him on my first stream with me. La la la. Now, Uncivil Law. I gave a 5 to 7 minute explanation of why I have trouble with guests and how I work all these things around my firm. And I was not trying to ghost you on any of that stuff. And obviously, we've been on a lot of streams together since then. But I appreciate you trying to cause trouble in my chat. What else we got here? At Hoeg Law, do you hope that Microsoft will bring back the King's Quest series? Yes, that's what I said. Yes, absolutely. I would love to see adventure games come back. In fact, the 2015 King's Quest from The Odd Gentleman is fantastic. Go check it out. If you haven't played it, Christopher Lloyd voices Old King Graham. It's got a lot of cool ideas as an episodic adventure that's been done for years and years and years, so you don't have to worry about that. Really, really love that game. I don't think it took off. I don't think it made Activision much money. That was one of my first kind of interactions as a fan with a game developer. My daughter was so young when we first played King's Quest Revival, and I was so happy with it, and I was so happy that she was happy with it. We emailed a gentleman just tell him how happy we were with it and the family relationship and everything. They sent us back like a 7-paragraph, 8-paragraph, couple thousand-word email talking about how the game came to be, and that's what they were focused on, and family, and how appreciative they were of getting that kind of thank you note. I love that. I love that in the industry. There are so many dreamers and so many people that are out there trying to make the best content they can, whether they're under Activision or another big company or otherwise. I love those stories. And so always remember, if you love a game and it's unexpected, even if it's a big publisher, send them a note. They're still human beings. It's fantastic. At Hoeg Law, any thoughts on Cloud Imperium Gaming raising money for Star Citizen by selling ship pledges and then always nerfing the new ship the next patch? No, I mostly stay out of the Star Citizen stuff. I think at this point in time, you either know what you're getting with Star Citizen or you don't. It's effectively, specifically a kind of money pipeline. They have been, I think, fairly obvious with how their progress is going in at least the recent past. And Star Citizen, as it was originally pitched, I don't think I'm breaking any news here, is never going to exist in the fashion that it was originally concepted out as. So if you like what you're getting, if you like the progress they're making, and you want to put in another $75 or what have you, more power to you. I get some great support from super chats for me talking to people on a video. I get great Patreon support for doing YouTube videos. I can't really blame anybody for going and getting money that way. We try not to nerf our videos after they're released. I don't know what that would even look like. But I think as long as it's a practice that is now expected, that you still expect them to balance their game in some fashion, no matter what ship you've bought, it is what it is. I'm not an investor in Star Citizen. Just having these conversations will have some Star Citizen fan come into the comments. But that's where I sit on that particular game. Seems like the new cloud gaming space is the place where monopoly antitrust concerns will be the most potent, but are new and emerging spaces typically treated differently? Yeah, no, I think they are the most potent there. I think in terms of infrastructure, cloud services, server infrastructure, Azure, that kind of thing with Microsoft is where you would make hay if you were a regulator and you thought you saw a problem here. And no, they're not treated that differently. In fact, sometimes they're treated with more protection than otherwise, because the antitrust regulators are concerned that you could squeeze the life out of a nascent competitor or a brand new, potentially competitive marketplace because you're strong, because you're old, because you have cash. And so they can often be very protective of those. That's the mistake that I think people that report on this make, is assuming that we're just talking gaming as a market. There are not only sub-markets within gaming, whether it's mobile or recurring revenue or what have you, there are sub-markets within those sub-markets to focus specifically on infrastructure and cloud servers and things like that. So there's always a possibility. And in this environment, there's more than a little possibility that someone could decide to make trouble for Microsoft in this acquisition. So I think that's 105. Oh, former Ensemble studio employee here, Matt Pritchard. One fear about a studio being acquired is that the studio may be more limited going forward as to the types of games they are allowed to make. Some types of games won't be seen as making enough money. Competing with titles from other studios are subject to influences, demands from outside the studio, can only run on Windows 11, etc. Absolutely. You've got a new boss, and while they might feel the same as the old boss, that new boss has his own stuff to drive. Right? Phil Spencer, CEO of Microsoft Gaming, is also getting edicts from the people above him and in different places of a $2 trillion company. So managing how much of a heavy hand you're going to use on your new content providers, what you're going to require of them, even though you want to tell the world that you're not requiring much of them, is part of that story. Right? The good news is, in a lot of these acquisitions, you're worried about getting fired. You're worried about redundancies, and that doesn't appear to be the case with Activision, although there might be back office stuff that might have that particular issue. So you're likely to keep your job, I think, as a developer of these things. But yeah, you don't know what Microsoft is going to require. And to be frank, Microsoft has never, ever developed content on this scale. They don't quite know what they're going to require, how this is going to be handled across all this multitude of studios. Thank you very much for the comment, Matt. That was fantastic. At Hoeg Law, do you think there are alternatives to law school will ever become viable in the next 5 to 10 years? Those are two questions. Ever become viable? Yes. In the next 5 to 10 years? No. One thing is that, as we have seen in the pandemic and elsewise, the university infrastructure, whatever you want to call them, including law schools and graduate schools, has an iron grip on certain political classes and certain zeitgeist understanding, right? You want to go to college, you want to make money, you want to have a good life. And so even though I think law school realistically could be reduced to a year or a year and a half, getting you the fundamentals, teaching you how to think like a lawyer and sending you out, and getting real practical advice, and even switching, if you wanted to some kind of apprentice system where you're not a full lawyer, but you're actually learning how to practice law. While I think that could work better, I honestly do. And I loved my time at Michigan. I loved law school, but I think it could be more efficient than it is right now. I think that law schools and the prestige they give to universities and the universities themselves are going to lock that in for longer than maybe you or I would like. Okay, a couple more. I'm getting questions. We'll go a little bit longer than just the 1 hour here. Any thoughts on Earth 2 or Crypto Land projects? Did a video on Earth 2 and their terms of service. I'm very standoffish on the entire concept of those kinds of things, but I also don't fall on the line that you see on YouTube, calling them fraud, calling them schemes necessarily. You can function that way. There are some that do. It's a little early to jump on just calling those things, to my mind, if they are open and honest about what they are. Fraud requires deception, and I don't think that that's happening in every instance that they get in trouble on here on YouTube and elsewise. One thing Microsoft could do with a game like Space Quest is license it out to a smaller company, like Odd Gentleman. Absolutely. Microsoft actually did that when a company wanted to make a Shadowrun and Battletech MechWarrior game. Absolutely. Yeah, one thing that you could see is essentially the Star Wars Disney approach, saying, all right, we've got an IP that's very valuable, and here you go. But I think we all have to be honest with ourselves. King's Quest and Space Quest are not Star Wars. And so while I would be more than happy for a small company to take a run at it, I also don't want that small company to scuttle itself because it tried. I don't know. Does anybody know what the Odd Gentlemen have released since 2015? Do they still exist since they put out that King's Quest game? I don't know. I can't answer that question. Nothing comes to mind. That doesn't mean I'm right there. So I worry about that. That's essentially outsourcing risk. And while that can make sense to get us a product, that can have very negative effects on the people that actually made it for us. What do you think will happen to the evilness, so to say, at Activision Blizzard if Microsoft loses the deal? As my understanding, the government can't do anything like fire people, but it is the hope for Activision Blizzard to be gone. Yeah. So we saw with the EEOC settlement, for the most part, these regulatory agencies can't just go and demand firings without some kind of finding of fault, right? And these lawsuits aren't against specific people for the most part. They've got some John Doe slots in the California lawsuit and things like that. But they aren't against who you're really concerned about, I think, in that question, which is the leadership that led to that culture. And so what would happen if the Microsoft deal were to fall through? You'd have a massive correction of the Activision stock price. You'd have a reflection from the board of whether or not they like the direction things are going in. And I think you would see a massive organizational change. Would that get you to where you wanted to go? I can't say. But I do think the internal pressures from that deal failing that the board had pushed through, from the normal human psychological loss of a thing that you thought would happen, a deal that was going to occur, not occurring, I think that you get to a place where you do have that significant sea change at Activision Blizzard. Can you please answer my one last question before signing off? The Deadly Eight. Well, you didn't spell my name right. That's why I didn't see you. Hoeg Law, do you think Disney crossed the line now and can't buy any more studios? They will surely alarm antitrust and monopoly laws if they buy someone like Sony, right? So the legacy media, I think, if regulators are looking at it correctly, is maybe even more tumultuous and competitive than video gaming, insofar as we see Amazon and Netflix pouring money into trying to compete. We see Hulu, we see Peacock, or does anybody see Peacock? I don't know if anybody sees Peacock. Comcast, I think, just announced they have to spend $5 billion more to try to make content that people will actually watch on that channel. But you see this competition in pipelines. And so I think Disney could do more. I think they could purchase a few more. But understanding that the Biden administration, unlike the Trump administration, and even the Obama administration, has rattled the saber more, that they want to stop mergers and acquisitions on a more aggressive level. Right? There's no right or wrong answer here. There's essentially a gray area when you're dealing with an acquisition that you think that something could cause a problem with. Biden administration wants to enforce them more aggressively. Earlier administrations wanted to enforce them less aggressively. So even Disney would have to worry about regulatory concerns for those kinds of things. But I do think there's space in the legacy content delivery service to still have more acquisitions and consolidation. Okay. I think that's every question. We went an extra 10 minutes. I hope everybody had fun. I love doing these question times with you all. Thank you for asking all the questions. Thank you for the patrons who asked their questions. I'm always thrilled to see it. Please do check out those tiers. If you want to make sure your question gets asked, gets a fancy slide that I work on, highlight various things for you. Please do check that out. I love the support from everybody. It's been a fantastic month for the channel, even though I got COVID earlier. We had to take a week or 10 days off. I thank everybody for the well wishes for all of that as well. And thankfully, I was good to go by the time Microsoft dropped a hammer on me on a Tuesday morning a little while back. So thanks everybody for dropping into Question Time. Please do check it out. I will be on Gaz Live. I'm forgetting the name of his show. I apologize. At 4 p.m. today, talking about the Microsoft acquisition. So please do check that out. And I will catch you on the next episode of Virtual Legality. Thanks, everybody. Have a great weekend.